The U.S. House of Representatives has advanced a major set of immigration bills in February 2026 that, if they ultimately become law, could reshape how immigration works in America, covering enforcement, legal immigration backlogs, and a long-earned legalization pathway for some undocumented immigrants. Even if you're not political, this matters to you. Because House passage is often the moment when proposals stop being just talk and start turning into real deadlines, real eligibility rules, and real risks for families, especially in states like Texas, which has the longest border and one of the largest immigrant populations in the country. Whether you're waiting for a visa approval, applying for a green card, seeking asylum, working on a temporary visa, or living undocumented and worried about your future, what moves through Congress can directly affect your options, timelines, and strategy over the next several months. My name is Asad and welcome to Immigration Newsroom. My goal is to explain what these bills claim to do in plain language, what could change for different immigrant groups, what still has to happen before anything becomes law, and what you should do right now, so you're not reacting in panic later. One important reminder before we begin. A bill passing the House does not mean it is law. It must also pass the Senate and be signed by the President. Many bills are amended heavily, merged into larger packages, or fail entirely. So treat this as what's on the table, not a final outcome. Now, according to the details circulating around this House package, there are 3 separate bills that moved forward. The first is an enforcement-heavy bill described as the Secure Border and Interior Enforcement Act of 2026. The core idea of this bill is major spending and expansion, more border infrastructure, more surveillance technology, and a major increase in federal enforcement staffing. The bill proposes billions in funding over multiple years, including money for physical barriers, drones and sensors, and large-scale hiring. If a bill like this is implemented, Texas would feel it strongly, not only near the border, but also inside the state, because increasing Border Patrol and ICE staffing changes day-to-day enforcement patterns. That can mean more workplace operations, more detention capacity, and more removals, especially if the bill also tightens legal standards for relief. One of the most controversial parts described in this bill is a major shift in how asylum claims are handled at the southern border. Under the proposal, many asylum seekers would no longer be paroled into the U.S. to wait for their case. Instead, they could be routed into processing centers outside the U.S., and only those who pass an initial screening would be permitted to enter. Supporters argue this deters fraudulent claims and reduces strain. Critics argue it pushes vulnerable people into dangerous conditions and raises serious legal questions under U.S. and international refugee obligations. Another major change described is pressure on immigration court timelines, fast-track dockets with strict deadlines. That sounds good to people who want faster court, but immigrant advocates warn that shorter timelines can also mean less time to find an attorney, collect evidence, and build a defensible case, especially for detained people. And there's another part you need to understand clearly: expansion of the types of offenses that could trigger deportation. Under the way this bill is described, it would broaden what makes someone deportable by adding a category framed around public safety offenses, potentially including things like DUI convictions and certain misdemeanor conduct that, in the past, may not have triggered the same level of immigration consequences for some lawful permanent residents. That matters because many people think, I paid my fines, I completed probation, it's over. In immigration, that's not always true. A past criminal record can resurface years later, especially if Congress expands deportability definitions or reduces eligibility for relief. If you're a green card holder and you have any criminal history, especially DUI, domestic-related issues, drug possession, or repeat traffic problems, this kind of bill is a warning sign. Talk to an immigration attorney before you travel, before you apply for citizenship, and before you file anything new with USCIS. Now, the second bill in the package is described as the Legal Immigration Reform and Backlog Reduction Act of 2026, and it moves in the opposite direction from the enforcement bill. The big promise here is backlog relief and modernization of legal immigration. One centerpiece described is eliminating per-country caps for employment-based green cards. Today, per-country limits are a major reason Indian and Chinese applicants can wait many years, sometimes decades, in certain employment categories. A change like this would shift the system toward priority date is king, regardless of country of birth. The bill also proposes increasing the total number of employment-based green cards available annually, plus additional increases triggered by demand. If enacted, that could help U.S. employers retain talent and could reduce long-term instability for workers stuck in extended waits. On the family side, the bill described would raise the number of family preference visas and introduce a faster processing lane for parents of adult U.S. citizens. Though parents are already considered immediate relatives under current law, the proposal focuses on speeding processing with additional requirements and targets. But it also includes a major trade-off, eliminating the sibling category for new filings. Under the description, current sibling petitions would be grandfathered, but new I-130 petitions for siblings would stop once the bill becomes law. That would be a big change for many communities that have relied on sibling sponsorship for family reunification. If you're a U.S. citizen and you've been planning to sponsor a sibling, a proposal like this is exactly why people rush to file before the law changes, because grandfathering often protects people already in line. The bill also keeps the diversity visa lottery, but reduces the number of DV visas, shifting those numbers to reduce backlogs elsewhere. Another interesting feature is a proposed startup or entrepreneur visa, designed for founders who create U.S. jobs and meet revenue or investment benchmarks. Texas could benefit from this, especially in cities like Austin, Dallas, Houston, and San Antonio, where entrepreneurship and tech growth are strong. The bill also describes major modernization of USCIS processing, expanding electronic filing, online tracking, and broader premium processing availability. That could speed up many categories, but it can also deepen a two-tier system where those with money get faster decisions. Now, the third bill in the package is the most politically sensitive. It's described as the Earned Pathway to Legal Status Act of 2026. This bill proposes a conditional legalization system for certain undocumented immigrants already living in the United States, without calling it amnesty and without offering immediate citizenship. Under the described framework, eligibility depends on a strict cutoff date. You must have been continuously present in the U.S. since January 1, 2020. If you arrived after that, you don't qualify. It also requires a clean enough record, no felonies and no more than 2 misdemeanors. It requires ongoing participation through work, education, or caregiving. It requires background checks and biometrics. It includes basic English and civics requirements. If eligible, the person would receive a temporary conditional status for 8 years. During those 8 years, there would be strict compliance requirements, ongoing work or school, tax payment, annual check-ins, and no criminal violations. After 8 years, the person could apply to adjust to lawful permanent residence, a green card. Then, after obtaining a green card, they would still need to wait the usual period before applying for citizenship. That creates a long timeline, often described as at least 13 years from undocumented status to citizenship. Dreamers, people brought to the U.S. as children, are described as having a faster timeline in the bill, with the ability to adjust sooner. Now, here's the part many people underestimate. Proof. A bill like this rises or falls for real families based on documentation. Continuous presence since 2020 sounds simple until you're asked to prove it month by month. The documents described as acceptable include leases, utility bills, bank statements, pay stubs, school records, medical records, and sworn statements from witnesses. But many undocumented people have cash rent, informal work, shared housing, and minimal paperwork. So if you think you might qualify under a proposal like this, the most important thing you can do right now, before anything becomes law, is gather proof, quietly, safely, and in an organized way. The bill also describes substantial fees, not small fees, large multi-year costs per person, plus future green card and naturalization fees. A family could face very high total government filing fees over the full timeline, not even counting attorney fees and translations. It also restricts access to federal public benefits during the conditional period. That means you may be allowed to work and pay taxes, but still be blocked from the safety net during hardship, with limited exceptions. Texas has one of the largest undocumented populations in the country. If something like this became law, it could impact hundreds of thousands of people in Texas alone, but the requirements would also exclude many. Now, here's what happens next. All three bills have only moved through the House. The Senate is a different battlefield. Immigration bills can be amended heavily, merged into a single package, or blocked by the filibuster if they can't reach the vote threshold. Even if the Senate passes something, the final text could look very different than the House version. Then the president must sign it. Then agencies must write rules, build forms, train staff, and roll out implementation, often taking many months. So what should you do right now? If you are undocumented and might qualify under an earned pathway proposal, start gathering documents now. Proof of presence, taxes, school records, medical records, anything with your name and date. Organize it by year and month. Don't wait for an application window to open. If you have an ITN and you've been filing taxes, keep filing. If you haven't been filing, speak with an immigration knowledgeable tax professional about how to correct that safely. Tax records can be powerful evidence of presence and compliance. Avoid criminal trouble, especially now. Even minor cases can block eligibility. And if you have old cases, get certified disposition so you can prove what happened. If you are on a temporary visa, maintain status perfectly. Don't overstay. Don't work without authorization. Keep your address updated. Bills like these often increase penalties for violations. If you are in an employment-based green card backlog, especially from India or China, monitor this closely. But don't make irreversible life decisions based only on a House vote. Keep maintaining status and progressing under existing rules. If you are a U.S. citizen planning to sponsor a sibling and you haven't filed yet, understand the risk. Proposals like this often grandfather petitions already filed. Filing earlier can preserve a place in line if the category is later closed. Be extremely alert for scams. Whenever legalization bills appear, scammers multiply. Nobody can file an application for a program that doesn't exist yet. Only work with licensed attorneys or DOJ-accredited representatives. And if you are an employer, start preparing for possible changes. Identify employees stuck in backlogs and talk to your immigration counsel about how reforms, if they pass, could change timing, retention planning, and filings. The bottom line is this: the House advancing a package like this is a major political signal. Whether it becomes law or not, it tells you what priorities are gaining momentum. More enforcement pressure on one side, and major legal immigration modernization on the other, with a conditional earned pathway as the bridge. This is Immigration Newsroom. And I'll keep tracking what happens in the Senate, what gets amended, what survives, and what it means for real people. If you want ongoing updates without panic, subscribe and turn on notifications. And in the comments, tell me which part affects you most: enforcement changes, backlog relief, or the earned pathway proposal, so I can make the next video focused on your situation.